Can I just say something about Andrea?
Welcome back, everybody. After our long weekend this weekend, it has cooled off here in Los Angeles, and I appreciate that so much because I was not dressed for the heat wave that we had. I was very unprepared for that, super unseasonable. But things are a little bit more normal now, and so all is good. All is good. Got plenty of rest and had a little bit of a good time. And so we're back today for day five of the trial. Ioan Gruffudd versus Alice Evans. And today was just kind of it was just marked by things not going as predicted. I think in general we're starting to see that the cases may be taking a little bit longer than the parties had originally expected. Some of the witnesses are going longer, and the scheduling just hasn't quite worked out, I think, as they've anticipated. Today was kind of like the cluster of all of that. I also, by the way, I'm noticing we're having a little bit of glitchy internet tonight. So I might freeze up from time to time, but so far it hasn't like completely booted me off or anything like that. So it might freeze me at like a weird expression or something. Oh well, that happens. But it's just par for the course for today. Tech issues were just one of the many issues that led to us being delayed. It started this morning because the judge apologized when he came out on the bench at 9 o'clock. He explained that he got a phone a friend, basically, like Who Wants to Be a Millionaire. He got a phone a friend call from another judge who needed some help with the case, and so he ended up on the phone with this other judge for like half an hour. So that was why we got started a little bit late today. Then the afternoon, the witnesses were supposed to appear by Court Connect, and just getting that set up, it was chaos. There were some very amusing parts to it, which I'll get to when we get there. But we'll start at the beginning. Have to do our fashion update. Today was all black. Today was funereal. Today was all black. Alice was in this long sleeve, midi length dress. It was a dress with like a fitted top, a drop waist, like a low waist, and just sort of draped kind of hem, not a straight hem, just like kind of like what we've been seeing, what we saw last week, the sort of draped looking midi hem. She was originally wearing this black jacket over the top. It's like another kind of trench coat looking jacket, except it has a very wide like ruffle at the bottom, big ruffle. The belt that's tied like a raincoat. And then I noticed she had this, I thought it was originally these like just a whole like stacked silver bangles on her arm. But then I saw it was actually a big bracelet, like a big wristband that she had on, over the sleeve of the dress. And then before court was getting started, she reached into her purse to pull out this other bracelet, and I think it was like a charm bracelet because it had a jingle bell on it. So the bell was jingling quite noticeably. And so she pulled that out of her purse and put that on like before court started. So I don't know if this was like a comfort bracelet or something, but the jingle bracelet was a late add-on. So we had a new court reporter. So we did the announcement of the appearances yet again. Everybody stood, and today we had a big smile from Alice. We've had a lot of inconsistency with the appearances, but today we had a stand and a big smile when she was introduced. Just during the preliminary part of the hearing today, at some point there was a noise coming from somewhere. It sounded like, I don't know, somebody had something playing, and the audio was on a phone, on a laptop, on something like that. So the court heard it. They couldn't tell where it was coming from. And so we got an admonition, everybody in the courtroom, reminder, no devices, have them off, no recording, no broadcasting. Any violations will be referred for criminal contempt. So wasn't me, I wasn't worried, but that is out there. It is out there, the criminal contempt. Just by way of a quick legal explanation, you have civil contempt and you have criminal contempt, and civil contempt is typically remedial. It's where we just want to fix a problem, like you're not doing something you're required to do. A classic example of this one is in like the federal courts, where they don't have the reporter shields, the reporter shield line in federal court. And so sometimes the reporter will be called in to testify about where they got certain information, and the reporter will refuse to provide that information on principled grounds. It's not First Amendment protected, but so because of that, they will then be found in criminal and civil contempt. They're found in contempt of court, and so the civil penalty is you get imprisoned until you're going to comply, because the whole point is just we're going to try to get you to comply with what it is that you're supposed to do. So you hold the key to be able to purge, to be able to purge the sanction and put an end to it. Criminal contempt is when we're punishing you for something that you did. So it is not remedial. It is not something that we're doing just to sort of lean on you to get you to change your ways. It's something that you did and you're going to be punished for. So that's what the threat was. We will punish you if we catch you recording, broadcasting, anything like that in the courtroom. We started off by asking if there were any other witnesses for the defense to present on the DVRO renewal. Ms. Verano said no, but she did want to make sure that there were a few items that were moved into evidence. And so we had a one part of a message that was previously admitted, like was also on another page, and so the other page got admitted. And then Janina also wanted to move into evidence the transcript from the August 2nd, 2022 hearing, when Ioan got the domestic violence restraining order issued in the first place. It was a short hearing. It was only about 14 pages. So that is now in evidence. And then the defense rested, and there was no rebuttal case. So we clarified, this is just on the renewal. There are other issues. We're not resting on all of those. This is just on the renewal part of the case. Mr. Green, Patrick Green, arrived early. He got there since the judge started late, and then Patrick Green got there a little bit early. We went to Patrick Green rather than the original plan had been, we're going to do the closing statements, the closing arguments on the DVRO renewal, possibly get a ruling on it, and then then move to the testimony. That didn't happen. We in fact never got to the arguments or ruling or anything like that on the DVRO. We only took evidence on the financial issues today. So Patrick Green was called to the stand. This guy is flashy. Okay, this guy looks great. This guy, he knows how to dress. When I say he's a very large black man, I don't mean he's fat. I mean he's tall. He's tall and he's solid. He's built like a running back. And he's this very bright blue. I don't even really know the color. It was just not quite as dark as a cobalt or like a royal blue or something like that. It was a lighter tone than that. Very, very bright blue. Then his shirt was this white shirt with a cross check pattern of orange or pink and blue, like checks, and then this bright pink Pepto-Bismol colored tie. But it had some kind of like texture to it, so it wasn't another color, but it just gave it, it gave it depth. It made it look richer than just like a plain Pepto-Bismol tie would be. And then the shoes, I had to lean over the bar to get a good look at the shoes, because these shoes, holy cow, they were these tan. I'm pretty sure they were alligator. They could have been like some kind of snake, but I'm pretty sure they were alligator. These tan alligator shoes. It was quite a look. The man makes quite an impression when he gets on the stand. So he was sworn. They estimated he would take about 2 to 3 hours. He did indeed go until noon on everything. So he is a forensic accountant with offices in Thousand Oaks and Encino. He is the managing director at his office. Ms. Verano offered to simply stipulate to his expertise in forensic accounting and family law. She indicated she had worked with him several times in the past, so she's familiar with his qualifications. His CV was entered into evidence with one oral modification, which was that as of February the 1st, his firm had been merged with another company called CBiz. So CBiz now owns his company and he is now an employee. So he probably got a big payday. Is kind of what that read to me. You got a big payday and you still have a job. You get paid for it, but somebody else is the boss now. So the court accepted the stipulation as to his expertise. Asked for the scope of what he was asked to evaluate, he was asked to determine the party's income available for support, determine the guideline child support, report regarding the child support and the allocation, child support paid and allocation of child-related expenses, spousal support calculated based on the premarital agreement, determine whether Ioan's payment of support exceeded the premarital agreement, determine credits and the community property balance sheet, and taking into account a stipulation regarding the allocation of assets that the parties had been able to reach. And then lastly, to talk about meet and confer activities that took place between him and Ms. Lesgard, who was Alice's forensic accountant. So they had indicated previously that she was not going to testify. And it's not entirely clear to me now if we're still back in that just not testifying because of the DVRO part or not testifying altogether. It seems that it may be that she's not testifying altogether. And it's potentially the reason why is because Mr. Green seems to be abundantly fair in how he presents his testimony. He's not hiding the ball as to the nature of the disputes and what they are. So much of his testimony is addressing the disputes that he had with Ms. Lesgard and what they were based on. And so the reason why Ms. Lesgard may not be needed to testify is because it seems that a lot of these disagreements have to do with legal questions, not accounting issues. They're questions about how do we interpret the premarital agreement for the most part. And so it's very possible that those are just going to be addressed in the closing argument. Janina will address those when she makes her position to the court. So there was a list of documents that he reviewed as part of his analysis. He indicated that there were additional records that he wanted that had not been provided. Specifically, neither party had records documenting their separate property all the way back to the date of marriage. So any separate property claims based on things like that were unable to be traced. It appears that that largely affects Alice, as we'll get to. He wrote a report, which was admitted into evidence in its entirety. And so his report first off, we turned to the parties' income available for child support for 2024 and 2025. Ioan's income he determined to be on average $15,634 per month. It was $12,646 in 2024 and $18,621 in 2025. So took the average of that, $15,634. The sources of his income are his loan out corporations. They have the Fair Oaks Corporation, which was intended to hold their community income, and the Derwin Deg, which was intended to hold Ioan's separate. There were miscellaneous wages that he received, residuals, and dividend income. So to calculate the net income, he took the gross receipts on the profit and loss for the businesses, less the expenses, and then added back some non-cash expenses that were related to depreciation. So like accounting expenses that aren't like really real in the real world. They added those back in for purposes of being able to calculate the income. And also acknowledge that the corporations, they paid perquisites, but they were pretty de minimis. They were nominal. In 2024, Ioan received a $50,000 salary from Derwin Deg, but he did not receive a salary in 2025. There were also miscellaneous salaries that related to a few projects that he'd worked on, including Black Hawk Down and Fantastic Four. So he must have gotten some kind of payment for like promotion or something for Fantastic Four is kind of what I assume, because this is 2024, 2025. Obviously didn't film anything for them in that time period, and this isn't being reported as just residual income. So it seems he perhaps got some kind of payment related to maybe promotion or something like that when the last movie came out. He treated for child support purposes residuals and royalties as 100% available. Spousal, the calculation is different because of his interpretation of the premarital agreement. But for child support purposes, they include residuals and royalties as income. And as far as he knows, there is no dispute about Ioan's income for purposes of child support. So they seem to be in agreement on that. Alice's income available for child support for 2024 and 2025, he came up with $4,880 per month. This was based on an analysis of bank deposits from January 2024 to March 2025. That period was calculated by Ioan's bookkeeper, and then the remaining period from March to December of 2025, his office did the analysis, the accounting for that. And so what they did for that analysis is they took all of the deposits, they removed out amounts that were paid by Ioan to her, because those wouldn't be calculated in that equation. Wouldn't count as income, and then bank transfers that were just between accounts, and so they were obviously not income, they were just money being moved. There were some differences between his calculation and Ms. Lesgert's calculation. She came up with $4,033 per month of income for Alice, and that was based on differences of opinion regarding how to categorize a few different types of sources of income. First, there were GoFundMe deposits. There were travel expenses that were paid to her, and there were proceeds from the sale of personal items. And so these are just basically the arguments that were raised in Alice's trial brief as to her opinion of the income that she received. So then based on those calculations, they came up with proposed guideline child support of $3,579 per month. This was based on certain assumptions: Ioan having no visitation, he's married, filing separately, treating Alice's income as the for, you know, the 4880. Ioan gets a $747 a month health insurance deduction, and then he gets 3 exemptions for tax purposes. Alice gets 1, is how all of that is allocated. So $35.79 a month is $579 more than he has been paying previously under the terms of their stipulation. That is kind of expected because his income has gone up, and so that's sort of normal when your income is a little bit variable, that there can be some movement around the edges. He also ran the calculation using Alice's number for her income, and he doesn't remember the exact number because he testified there was less than a 2% difference overall. So this is presumably not the entire reason that we're going to trial, right? 2%. Surely we're not going to trial over 2% of $3,500. Sure hope not. No, it's not, but we'll get to that. There is a calculation that they do for uncovered, uninsured medical expenses. He was not able to calculate this for 2024 because there were no child care expenses at that point to put into the calculation. And the way that his program works is you have to have something to put in to be able to get an allocation. And then also spousal support. It just depends. Is it paid? How much is paid? And so forth. So if no spousal support is ultimately ordered, then Ioan would be responsible for 64% of the uncovered medical expenses of the children. If guideline spousal support were paid, then it would be much closer to a 50-50 division of those expenses, because just the relative net income that was available to them would gravitate closer to equal. So that would all just depend on whatever the judge decides is appropriate spousal support award, if any. We then looked at the premarital agreement, which he is quite familiar with. He's able to rattle these provisions like off his tongue. You know, section 18.5 subsection A and B are what deal with how you calculate the income. And so he relied on the premarital agreement to calculate spousal support appropriate under that agreement, and then compare the actual support paid to the calculation of what the premarital agreement called for. So first we looked at the period for 2024 to 2025. And there is another exhibit that was admitted that was just this premarital support or this spousal support calculation based on the premarital agreement for this time period. In 2025, Ioan's income available for spousal support was $163,887, and this was including all income with the exception of some separate residuals that he received for Bad Boys 4, which was filmed after, you know, he got that after the separation, and then the Derwin Degg royalties, which were, you know, segregated out and kind of intended to have been held as Ioan's separate property. And so he excluded those based on the provision of the premarital agreement that says separate property income is to be excluded. Based on his calculation, the support that should have been paid in 2025 was then $16,389, but Ioan actually paid $18,000, so he had overpaid by $1,611. This is the smallest of the numbers that we're going to hear when it relates to Ioan's payments and overpayments of spousal support. In 2024, his income available for support was $151,756. Same basis, same calculation, except this one in 2024 he did not. He just said he just didn't bother to take the time to remove the royalties from separate property residuals and so forth. I wasn't sure if there were any from this time frame. So this was like, this is a generous calculation is basically what he's saying. So in this this calculation, the support due was 10%. It's $15,176. Ioan actually paid $41,000. So for 2024, he overpaid by $25,824. His again, material differences with Alice's accountant, Ms. Lesgart, specifically concerning in 2025 the removal of the separate property residuals. She did not believe that they should be removed, and so there was a $59,565 difference between their figures, which would amount to, you know, $5,956 in support, whether that was due or not in 2025. And this is all just based on the language in the premarital agreement that excludes income on separate property, including royalties and residuals. We then looked at the stipulation and order that had previously been entered for temporary payment of support, but subject to reallocation. So they understood at the time that they signed this that it was like a temporary thing. This is not the final numbers. This is just what we're dealing with for right now until there's a final decision that the judge makes about what is actually due. And so pursuant to the stipulation, the amount of spousal credit that was due was $28,677. What was actually paid from December 2023 to April of 2024 was $7,000 a month, so $35,000 for that 4-month period. And it worked out to $15,000, a little over $15,000 for a year, and a total overpayment of $6,323. And so if he gets that credit, if Ioan gets that credit for the overpayment, then it should be offset against future support or against the asset division, and that is for the judge to decide. So he worked it out then by monthly. It would be a $1,593 offset for 18 months. Just like as one way to kind of sort it out. Break it up over, you know, this total overpayment, break it up over 18 months. That would mean reduce Alice's monthly support by $1,593 for 18 months. So he analyzed the amount of support paid to or on behalf of Alice as support during the separation period from 2021 to 2025. And he prepared a schedule of that as well for the 2021 to 2023 periods. We've already talked about the 2024 to 2025 period. But now we're talking about basically everything before that. 2021 to 2023 plus the 7 months. They entered the stipulation in July of 2024. So that whole time period. In 2021, Ioan's income was $486,565. Now, under the premarital agreement, it calls for there to be a baseline income that's calculated based on an average of the 3 years preceding the separation. And so that was 2018 to 2020. And his average income during those preceding years was $588,134. If there is less than a 20% decrease from that baseline in any given year after the separation, then the amount due is 10% of the baseline, and that's the support calculation. But if it's more than a 20% reduction in income, then it is 10% of whatever his income is in that reduced year. So the first year in 2021, it was only a 17% drop. So the baseline support applies. That would mean the spousal due for 2021 was $58,813. According to Mr. Green, the amount paid to or for Alice's benefit was $264,101, meaning he overpaid by $205,288 just in 2021. Just in 2021. In 2022, his income dropped to $50,441. That was a 91% decrease from the baseline. So only spousal due that year was $5,044. He actually paid $152,166 to or for Alice's benefit. And so that was an overpayment of $147,122. These are kind of eye-watering numbers, aren't they? These are kind of eye-watering numbers considering, you know, Alice was supposedly left destitute, abandoned. He never paid anything, wasn't supporting the family. Yeah. Seems like that is, if we're being real generous, that's quite a exaggerated misreading of the situation. In 2023, his income was $219,528. That was a 63% decrease from the baseline. So the spousal support due was $21,953. He actually paid $28,817. So there was an overpayment of $6,865, meaning the total overpayment for 2021 to 2023, $359,275. So I did the math myself. When you take that amount and then you add it to the overpayments that we already talked about from 2024 and 2025, which were $1,611 and then 25,000. You know, we're getting pretty close. We're getting pretty close to, we're not quite at 400,000, but we're not too far off. We're at like 390. We're like 390 or so. This does not include, when he did these calculations, the removal of the separate property residuals, the separate property income. Says the overpayment would be higher if you go back and you recalculate it, but he did not do that when he did this calculation. And that's because the residuals as reported are not separated out. So you'd between what's community and what's separate. So you'd have to go through and you'd have to figure that out. He then did like an average of the 43 months of income that was available for support for these periods. Did it the same without adjusting for the separate residuals or the passive income. And not entirely sure why he did that. The judge seemed like he was not entirely sure why he did that either. But it was just to determine the gross adjusted income available for support for each period, and so it's part of his report. His report details the annual support amounts paid, the documents that he relied on, the income amounts for 2021 through July 29th of 2024, and yeah, what documentation he relied on. So then he took all of that yearly income and he put it into what used to be the Dissomaster schedule. I remember Dissomaster from like a long time ago when I like a million years ago, before I even went to law school. I used to be a court clerk in California, and I remember Dissomaster. It's just they have all of these standard like programs and forms and ways to calculate things and stuff in California. Apparently, I guess they don't use Dissomaster anymore. I'm not sure. Maybe it went away. But so they did run it way back then, but I guess he didn't attach the calculations. Don't know why. And what DissoMaster does is it calculates the guideline support. So that would show like if there was a difference between the guideline support and the support called for in the premarital agreement. I'm assuming they didn't attach it. They ran it initially because it was unclear, you know, are we going by the premarital agreement or not? First we were, then we're not, then we are, then we're not. It was like this kind of whiplash back and forth on is Alice going to contest this prenup or is she not? So that's kind of my assumption, is that they calculated it to see like, okay, if you challenge it, it's going to be this. If you don't, it's going to be that. Ultimately, they did stipulate to the validity of the prenuptial agreement, but not to its unambiguity, as we will get to in a moment. So my assumption is that he just didn't include the DissoMaster because it's no longer relevant. The premarital agreement is stipulated to be valid, then it's going to govern really no matter what. It's just a question of what it actually calls for and what it means. So then we start looking at the total amounts. There's a detailed breakdown, many pages, 21 pages of payments that are credited, allocated to Ioan as payments to Alice for the benefit of her and or for the children. So for treated as child and spousal support before the order was in place, but pursuant to the premarital agreement. There is a summary breakdown by year of each amount, the amounts that are allocated as spousal support and child support. So for 2021, there is $264,101 that's allocated to spousal, $152,166 for 2002, $28,817 for 2023, and those figures are reflected in his calculations as paid by Ioan for child support. Then there's a column for the children, expenses relating to the benefit of the children, what is allocated to, you know, basically child support. For 2021, there was $161,047 that was allocated for 2021 through July 29th of 2024. And so that's the total of the expenses that he paid during that time frame that benefited the children. It was a combination of direct payments. All of these allocations is a combination of direct payments and payments for the benefit of. He did not compare it to any child support obligations because there was no child support order in place. So that calculation wasn't done, but he paid is kind of the bottom line. He paid, I didn't do the math, but yeah, $161,047 over 12, 24, 36 plus 7 months, 43 months. You can do the math. You can do the math. So then in December of 2023, they had another stipulation, and it lowered the child support obligation. They stipulated to $3,000 a month. And that began on May 1st of 2024. We turn now to the community property balance sheet. And so what he did is prepared a side-by-side analysis of his allocation of community and separate property and Ms. Lesgert's analysis of community and separate property. The judge wanted a copy he could mark on for his own, and Mr. Green was like, I have 5 copies that I brought. He came so prepared. This guy is so prepared. He's very detailed, knows everything, like absolutely no question. If I was like in a high contested divorce in Southern California and needed an accountant, this guy, he testifies very well. The judge obviously knew who he was. He knew who he was when he came into court on last week on Thursday. Um, saw him immediately and acknowledged him, and raised the issue of him being in the courtroom, and are we going to get to him because he's sitting here and his clock is ticking, and so forth. So this judge has clearly seen him quite a bit as well, and seems to have a decent amount of respect for him. And after seeing him testify, I can really understand why. He's very organized and clear. We took our 10-minute morning recess at this point, and when we came back in, I had 2 observations. The first was that Ms. Verano, she had a really wide, long thread hanging from the back of her jacket, and I noted it, and kind of throughout the day just sort of waited to see, is her client going to help her out with that? Wouldn't you, as just a bro thing? Let me get that thread for you. I mean, it's a small thing. It's not a really big deal, but it was so big, it's extremely obvious. And but no, it was there all day. So I don't know if she ever caught it. And then the second thing I noticed was that Alice is she's drinking San Pellegrino, and I'm like, so what's the beef with my LaCroix? What's that about? We're not on the LaCroix today. We need some electrolytes. So when we came back after the morning recess, we looked at the summary of the differences on the community property balance sheet. So there were a few points of difference that we looked at. The first had to do with Alice's account at C Hoare. This is Hoare. C Hoare. It's kind of quite a name, but it's Hoare. This is a UK bank account. And so it had a balance of $168,950 that Ms. Lesgart treated as Alice's separate property. Mr. Green treated it as community property because there was no tracing done, basically, to no documents that were provided that was allowing an analysis as to what is the source of the deposits into this account, and are they separate or are they community? If they are community, then this account is potentially commingled. And if it's commingled, then you have generally converted your separate property into community property by converting it with community property, unless you are able to specifically account and trace the source of the growth of that particular asset. And so there wasn't documentation provided of presumably the deposits into that account for him to be able to determine, is a separate property that's going in that can be traced, or is this community property that's coming in that's being commingled? So that resulted in a difference between them of about $89,458 on their separate and community property balance sheets. There is then what he refers to as a 2640 reimbursement that creates a difference of $180,183 between their calculations. And this is based on the premarital agreement says that Ioan is entitled to recover his $750,000 investment in the family home, the real property that he owned at the time of the marriage, that became the family home. And so he was supposed to get that back, but he's also, under the terms of the premarital agreement, entitled to a 5% rate of return on that initial investment. And that is to be paid from the proceeds of the sale of the house. So Mr. Green calculated that when he followed the premarital agreement, then the net proceeds from the home rounded out were approximately 1.1 million. So after 750,000, capital is allocated to Ioan, then it leaves about $366,000 if you ignore the 5% return. But if you calculate the 5% return, then it essentially consumes all of the equity. There's nothing left that would be attributed to community property. And so all of the proceeds from the La Jolla sale are allocated to Ioan in Mr. Green's analysis. Another area of dispute has to do with attorney fees for the Meyer Olson something law firm, which is one of Alice's early attorneys. There's a $90,000 difference in their calculations on that, and that's based on a disbursement pursuant to a stipulation that was made for Alice's benefit to pay her attorney fees, but the stipulation says that it is subject to reallocation. So he treated that as that should be reallocated to Ioan because it was Ioan's separate property to pay her attorney fees. He should get that back. She apparently disagrees. She thinks he should have to pay for it. Surprise there. And then the last area of dispute concerned the payments to Dr. Dupay. Dr. Dupay was the custody evaluator, and their original order appointing Dr. Dupay said that the cost would be shared equally, and that unless one of the parties unreasonably interfered, I forget the exact language, but failed to take them to the appointments or whatever, it would costs could be allocated to one party or the other. But Alice's accountant treated the entire amount as attributable to Ioan, and no clear explanation for that. Just she thought he should have to pay it. It's not what the stipulation said. So with those line items, those 4 areas of disagreement taken into account, according to Ms. Lesgert, to equalize the community and separate property balance sheets between them would require a payment of approximately $182,960. That was an ish. I didn't get the exact number, but $182,960-ish to Alice. According to Mr. Green's calculation, to equalize the community and separate property interests, it would require a payment of $222,427 to Ioan. So the bill just keeps getting bigger and bigger and bigger. California, of course, is a community property state. For those of you who may not be super familiar with how this works, because I know many of you, maybe not right this moment, but folks watching in general, a lot of folks interested in this case are from the UK. Ioan is famously from the UK. And so, community property isn't a thing there. What it means is that any property that you owned before marriage and certain types of property that you acquire during the marriage, primarily inheritances or gifts, are your separate property. They belong 100% to you, and your spouse has no claim on them, so long as you keep them separate, don't commingle them with community property, and they maintain their character as separate property assets. Community assets, and this also applies to debts, by the way, it's the same thing with separate community assets, and debts are those that are acquired during the marriage. And so typically that means your income, you're working during the marriage, you're earning, that is a community asset. You use that money to buy a home, that home can become a community asset, and so forth. So unless it is otherwise designated in something like a premarital agreement, that's the general idea of what it is. So then when you get a divorce, you end up kind of having to go back and calculate for purposes of just dividing the property that the married couple owns. You have to go through and categorize everything first. You have to go through and determine what assets are we talking about? What is their nature? Are they separate property? Are they community property? And if so, what's happened to them since the separation? It's just, it can get complicated because you have, community bank accounts that you might pay things. You have separate property accounts you might use to pay things. And so that's what they're really talking about when they talk about the balance sheet, is making sure that everything is sorted out in terms of, who had what as of the date of separation, and how do we make sure that what they have right now corresponds with what they're actually entitled to based on the nature of their property. So after meeting with Ms. Lesgart, he prepared a new report. His overall conclusion is still the same as the old one. He still is of the opinion that Alice owes Ioan $222,427 to pay him back for his separate property that was spent for her benefit on things like her attorney fees and so forth. The only change that he made from his previous opinion relates solely to the real estate transaction. In his new report, previously he hadn't included all of the remaining funds in the blocked account being dispersed because the blocked account is now empty. It's all been spent mostly on attorney fees. So he updated his report to account for that. He previously had not included the 5% rate of return on Ioan's investment that the premarital agreement called for, because now the premarital agreement, the validity has been stipulated to. So now we know this applies. So he went in and added that in. And then lastly, there were, he described some errors in allocating expenses that he corrected. He just basically took Ms. Lesgart's position on it and made those changes. And so now they agree, except for the 5%. And so the way that broke down was that the net sale proceeds was $1,110,366. You pay first, Ioan gets a $750,000 reimbursement. The 5% income, because it's calculated over the life of the marriage, 5% per year, it ended up being $890,020. So that completely consumed the net proceeds, which at that point was $529,000. So he did not allocate like the negative amounts. Like technically Alice owed him even under that, right? How much? 890 minus 520K, another 350,000 under the terms of the premarital agreement that she signed. She would owe him that. But he didn't allocate negative. He didn't, treat that as a liability that she owed him. They just zeroed it out. So the proceeds zeroed out. They just all get allocated to Ioan. The total disbursements that Alice got from the real estate sale was $310,914. This again kind of goes to the destitute. Destitute, really? Really? Now I know certainly some of that went to attorney fees. Potentially a lot of that went to attorney fees, but I remember that very first stipulation when they first agreed to sell the home and they agreed to disperse the proceeds. 110,000 went to each party, like independent of what went to the lawyers. 90,000 went to the lawyers, 110 went to each party. And that was supposed to be to pay your living expenses. So I just don't know about this interpretation of destitute. I really don't. I really don't. And so the math, like the actual numbers, are not in dispute as far as what they are. What's in dispute is simply the allocation. How do things get divvied out between the parties? Who owes who, what for what? And he is treating, for example, the money that was paid for her benefit subject to reallocation under all of these different stipulations for Dr. Dupay, for Meyer Olson, law firm, etc., as being allocated to Ioan. Everything else other than the C Hoare account, the other categories of assets were agreed: securities, pensions, retirement, etc., automobiles, business interests, other assets. There were no disputes as to those things. But the C Hoare account of $168,915, he treated that as community property. Lesgart treated that as separate property. I just don't see, if they didn't account, if they didn't trace, and they didn't provide the documentation that's necessary to trace, I don't see a credible good faith argument that that's separate property. I'm just not seeing it. So they did enter their stipulation, as I said, to certain assets, how they were going to be allocated shortly before trial in 2026, when they were doing the mandatory settlement conferences. They couldn't get everything resolved, but they were able to agree on some of these issues. And so they entered a stipulation in January of 2026 to that effect, and he included those stipulated terms in his balance sheet analysis. And that was the extent of his testimony. I was kind of hoping we were going to get a little bit more detail about the things like, on the date when Alice claimed she had $26 in the bank account, how much did she actually have in the bank account? But he really didn't get into that, and all I can assume is that because they aren't calling him for purposes of the DVRO renewal, they're calling him for the financial part. That they I don't know, they didn't get into that. I didn't love it. I thought that was really important. A lot of those details came out during pretrial litigation in some of the declarations that were filed and so forth. And it's quite compelling. I think it's really important to establish the scope of the smear that Alice was perpetrating when she was out here claiming she has no money, and Ioan's left her high and dry, and she and the kids have nothing. And in fact, she has tens, if not hundreds of thousands of dollars in her bank account at the time when she's making these claims. And by the way, when she's making these claims to support asking the public for money in her GoFundMe, there is a very viable argument to be made that this is wire fraud. This is wire fraud when you misrepresent your financial status for purposes of getting people to rely on it and give you money, and you're doing this over the internet. Yeah, that's not a good thing to be doing. So I didn't love that we didn't get that testimony. I did think it was important because it goes to the smear, and it goes to the part of her campaign, to ruin him and to ruin his career, of lying about what's really going on. But they didn't go there. So I don't know if there's going to be, I still can't see the exhibits. So I don't know if there's stuff in his reports that might allow those conclusions to be drawn, but I kind of doubt it. So don't love that they didn't go there. We then went to cross. So first, we went to the dispute regarding some of the deposits that were used to calculate Alice's income available for support in 2025. One of those related to a sale of personal items. And the question was based on accounting principles. Would you normally include that as a income available for support? And his answer was that it depends on if there's a history of continued depletion of assets. If it's recurring, generally it is not included as income, but it just depends on the circumstances. And so some examples, he says he doesn't know what Alice sold. She sold apparently luxury clothing items on a site called The Real Real. And I didn't get a number for how much, but it's in his report. So when and if the exhibits, I mean, they will become public. It's just a question of when. It will be on there, whatever that amount is that she got from selling luxury clothing items on The Real Real. And so he said it's very possible that it could be income available for support. It would be taken for consideration. An example, if you have 10 items in your closet and this income is from selling one, you don't know if this is something that they are still intending to sell the other 9, and there will be recurring income. You would want to look at like a longer history of buying and selling. He doesn't know if it's like, is this a business of buying and selling? People do, flip stuff like that, collect things and then sell them. So he ran the calculations both ways. Second area related to funds that were gifted to Alice relating to travel expenses. For purposes of attending her brother's funeral. She cashed that shit in, guys. That what was it, $789, something like that, $790. This was a fundraiser. That's a Facebook site for fans of the movie The Christmas Card, which is like a Christian movie that she starred in. They fundraised for her to be able to go to her brother's funeral, and they got her like $800. She cast that shit in, guys. So they dispute over whether that is income or not. It's so nominal. $800 like one time is so nominal. So that's the argument for Alice's income, I guess. Then they turn to Ioan's income. And the exclusion of the separate property residuals is the main area of difference between the two sides. So because of the Bad Boys 4 residuals, royalties, whatever it was paid into Fair Oaks, and so he deducted the $43,784 that Ioan got for Bad Boys 4 from the Fair Oaks income. And that's because there's a note to the prenup that says the prenup, it excludes income from the plaintiff's separate property. And Janina says, but doesn't the premarital agreement actually say income on the party's separate property is excluded as well as passive income? He agrees. Yes, that is what the language says. I racked my brain like, what's she getting at? What's she getting at with this? Income on separate property? Is she just trying to say that this is related to, like, if you have a separate bank account and it earns interest, the interest on that bank account is excluded? It's just, it was unclear to me. The issue is that Bad Boys was post-separation. The actual work was post-separation, so it wouldn't count as a community asset. It's a separate asset. And I'm not clear why it was paid into Fair Oaks. I'm wondering if that was a mistake, because they indicated Derwent Degg was supposed to be the loan out corporation for the separate property. So I wonder if it was like supposed to go to Derwent Degg and didn't. It went to Fair Oaks instead, and that's why, they backed it out. I really don't know. There really doesn't seem to be a good argument to me that it's community income. It's post-separation. So it's separate income. She seems to be saying that if it's your actual separate income doesn't get backed out, but like interest on your separate income would. I'm not quite sure where she's going with it, but she's making an argument derived in the language of the premarital agreement, basically, that that should count. We established that he did multiple analyses of the community property balance sheet and the calculations and so forth. And in his other iterations, he did not deduct any separate property income when he was doing those calculations. And the Bad Boys 4 money was an actual business receipt that was paid into Fair Oaks. There was also 15,781 business receipts that were paid into Derwin Degg. So I think she's saying those are income that should be counted. He's saying they're not. It's a disagreement over how the premarital agreement is interpreted with how it defines adjusted gross income. And the term is defined in the prenuptial agreement as referring to gross business receipts minus customary business expenses and so forth. So she, I think, is saying because these were paid into Fair Oaks and Derwin Degg, that makes them income under the terms of the premarital agreement because they are a business receipt now. They're not passive, royalty residual type of income. So the prenup specifically defines earnings, and it includes residual income. But we established that whether to include or exclude the separate property residuals, this is a legal question, not an accounting question. It has to do with the interpretation of the premarital agreement. So it's not something he's going to decide. It's something the judge is going to decide. And that's why they have these disputed positions on it. And so if the royalties were not excluded, the income, Ioan's income for 2025 would be $223,452. So basically, what did we say? What did we say it was before for 2025? Before we said it was, let's see, this was monthly. We don't want monthly. Before we said it was 163,887. So it's basically just the difference between the 16,389 spousal support that he calculated he owed and then paid 18,000 versus she's saying the income should have been 223,452. So it should have been 22,345. So he would have underpaid her by $4,345 if we accept her calculation. Is that why we're spending $100,000 on a 9-day trial? Is that why? Is that what this is about? So Joe had objected to what the support would be under this scenario. He objects that it's argumentative and it misstates what the terms of the premarital agreement. The judge is confused. He says, "I don't understand your objection." Joe says it's she's asking a question that's presuming her legal position. And Janina says, well, it's a hypothetical. I'm just asking him to entertain a hypothetical. The judge asks, are we using royalties and residuals interchangeably? And Janina says yes. And the judge clarifies these are not the same thing. I don't know what the technical difference is. I really don't know. They seem a bit similar to me, but I don't know. Royalties are from a licensing, typically like from a licensing is kind of how I think about it. Somebody has permission to use your property or something like that. You get, you get a royalty, you get like a percentage of their profit that they make off of using it. Residuals, I'm not anywhere near familiar enough with to know exactly what those mean. They're just, created by contract. They seem to be kind of similar to royalties, but I don't know. The judge is very clear these are different things. But Janina, for purposes of her argument, is using them interchangeably. So the judge anyway overrules this objection because it's a hypothetical. And so that would amount to $22,345 support due for 2025, monthly of $1,862, meaning the difference between what he paid and what she got is $4,345. Is that what we're going to trial about? Sure hope not. Sure hope not. We turn to what Janina claims are two conflicting paragraphs in the premarital agreement. In one, the residence is titled as community property without affecting Ioan's separate property interest. And it has no provision for him to receive, the 5% in that one. And there's no separate reimbursement for monthly payments or appreciation of his separate property interest in that paragraph. So whether to assess interest or not, he agrees, Mr. Green agrees, is a legal issue that's related to the premarital agreement. This, as I understand it, seems to relate to two kind of unrelated provisions of the premarital agreement. It's a fairly long agreement, but the one that Janina is referring to is talking about just, yes, how it's going to be titled upon marriage, and it's going to be held jointly as a community asset, but that they have this provision that notwithstanding we're titling it as community, and that's presumably because we're going to be using community funds to pay for the mortgage on the house. So it would be, commingled and stuff anyway. But notwithstanding that we're titling it as community and we're using community assets to pay for it and so forth, that's not affecting the $750,000 initial investment that he made that is characterized as separate. The 5% interest provision is in a separate paragraph in the premarital agreement where they talk about the sale of the property and, what would happen in that instance. So it kind of seems to me like that's the more specific provision that would apply in this particular case, because we are dealing with the sale of the property and what he's entitled to. So that will be up to the judge to decide. But it really doesn't seem like a particularly good argument to me. The premarital agreement seems on its face to me to provide for him to receive the 5% interest. So if the interest is assessed, then it results in there being negative equity basically on the sale, but that is not, being calculated. Janina asked, if the interest assessed isn't it true? That means the total proceeds of the home sale are all reimbursement to Ioan. He says, no, that's actually not correct. It's negative equity. We're just not calculating that though. We're zeroing it out. And so the end result is that the community is awarded zero from the sales proceeds. All of the proceeds are allocated as Ioan's separate property. So now is where the judge brings up, okay, hang on guys, because we have this stipulation to the prenup, but it doesn't seem to resolve, the stipulation itself doesn't seem to resolve this ambiguity in the language that's being asserted. And so on the one hand, there's no stipulation here that says it's unambiguous. On the other hand, there's no reservation of specific issues that are still outstanding vis-a-vis the premarital agreement. So there's no language like that in the stipulation. What they have actually stipulated to is that the premarital agreement is valid and enforceable. But as to whether it is unambiguous, they have not stipulated to that. So he clarifies that that's kind of what the status is with all of the parties, and says, so then this is for the court to decide if it's ambiguous, and if it is, what it means. And that is apparently where we stand on the premarital agreement. As with the spousal support, where he didn't, he prepared like various iterations and didn't always back out the separate property residuals. Likewise, he prepared several iterations of the community property balance sheets. In many of those, he did not assess the 5% interest. He estimated a handful that he prepared. And so there was one that he did August 3rd of 2023, where he did not assess the 5% interest. And then the one he did in his Exhibit 26, which was shortly before trial because he modified it in January after the stipulation. I think it was in December of last year. He hadn't included the 5% assessment. We established he was retained by Ioan in approximately January of 2022. And so over that time frame, there were approximately 3 others that he prepared without the 5% interest being calculated. Joe objected to this as potentially implicating the settlement privilege. You don't get to talk about settlement negotiations in court in California. That is off the table. But that objection was overruled. So the court did hear that testimony. I don't know that it matters. What he prepares or didn't prepare has nothing to do with, you know, what he's owned and whether the judge is ultimately going to conclude the premarital agreement allows him this 5% or not. And if he's being nice by not assessing it previously, or if he's not assessing it previously because she's all over the place on whether we're going with the premarital agreement or not, then it's kind of legally insignificant. So this is being presented as a little bit of a gotcha, you know, but I don't think it particularly gets there. It's really not relevant. Then we moved on to Alice's C Hoare account. And Janina asks, you testified that Alice didn't provide documents for the account from the date of marriage. And he said, that's not what I said. She didn't provide complete documentation for the account. So we then get an exhibit proffered by Janina that are account statements for this account that apparently had been produced that were from January 22nd of 2007 through January of 2013. So it's very limited selection of statements from the account, but it, you know, going back to 2007 would include the date of the marriage, but it only went up to 13 years ago. So these were ostensibly sent to establish the separate property nature of the account. All of the figures in this are reported in British pounds. This is an account in the UK, so these are British pounds, not dollars. There is a conversion rate. Alice's accountant used a blended exchange rate of 1.41, just meaning the exchange rate was averaged over the time period of these accounts. And so at the date of the marriage, the statements reflected that she had a balance of 22,105.42 pounds in that account. So that was the separate property that was properly disclosed in the premarital agreement. That was this account. The lowest the balance ever got was in October of 2009, where it showed a balance of 10,480 British pounds. There was a deposit from what is referred to as a capital account from June 11th of 2013 of 90,784 British pounds. And then it seems the account was closed in 2013. This account, it's very confusing, because if it's closed, then why would you be allocating anything as community or separate anyway? If it's not an asset to be divided at the time of the separation, then why would we be disputing it? I got quite confused about this. They corrected that date then to being closed June 23rd of 2011. When asked if he knew where Alice's earnings during the marriage were deposited, he said no, but reviewing these account statements from the C Hoare account, I can see that there are some earnings that are being deposited to this account. So she's commingling. If there's deposits into the account, you have to account for what they are. You have to account for what they are. If it's just earnings from during the marriage, that is community. You have commingled, and you have a duty now. You have an obligation to be able to sort this out and trace what's separate and what's community, and they haven't done that. We then had, we go back to the report that characterized the spousal support, the allocation of payments that Ioan made that were allocated to spousal support, and the alleged overpayments from January 1st of 2021 through July 29th of 2024. During that time period, or at least until the first stipulation in December of 2023, there was no support order in place. He agreed with that. The marital residence was sold in April of 2023, and Alice and the kids lived there from January 1st through the date of sale. So first he's asked if he's aware that Ioan didn't move out until the end of January 2021. No, he was not aware of that. And so if we're allocating the mortgage payments as payments for a benefit of Alice and the children to continue living in that home by themselves after Ioan moved out, well, it wouldn't be appropriate to allocate the full $36.80 mortgage payment to Alice for that particular month. And he agreed, yes, you would allocate it equally between the parties in that particular instance, because both would have benefited from the use of the asset. So 1 month, now we're back to arguing about approximately $1,840. Again, why we're back at trial. He acknowledged that the children remain living in the house. The community received $0 from the sales proceeds, but he allocated all of the mortgage payments to Alice. And Jania's point is that a portion of the mortgage payments includes principal, and so hasn't Ioan been reimbursed for the principal payments when he got when they did the home sale? And he kind of acknowledges, yes, he would have kind of gotten back his equity. Like, yes, that's what happens when you sell a house, you get your equity back. All of the earthquake insurance was allocated to Alice because she had the exclusive use and occupancy of the property. And he said that there is not a Watts and a corresponding Epstein on earthquake insurance. I'll talk more about Watts and Epstein in a minute. He allocated all of the insurance, the home insurance and so forth, to Alice. She's the one that's living in the home. She's the reason why it needs to maintain the insurance. She's the reason why the home can't be sold and Ioan can't liquidate his separate property interest in that piece of property. And if she wasn't living there, she would have to be living somewhere paying rent, right? So he agrees that the alleged overpayment of support does not include entirely. It's not entirely made up of direct payments to Alice. It includes payments that were made for her benefit. He agrees to that. She points to a portion of the prenuptial agreement that states that the payment of the other party's living expenses using separate property is a gift. And she asks, he asks, but is that during the marriage or is that post-separation? And she says, well, just look at it. And that's, objected to as argumentative and calling for a legal conclusion. And he starts to explain and the judge says, no speaking objections. I get it. I get what the problem is. He's overruling the objection. And Mr. Green says that's what it states. It does not state on its face in the language, during marriage or post-separation. It's the kind of thing that you interpret by context. You look at the context of this particular provision in the premarital agreement. And does it really seem to be dealing with, allocation post-separation? It really doesn't seem to. But it'll be up to the judge. Then we go to the payments to Dupay that, according to the stipulation, he allocated them equally. The stipulation he acknowledges says subject to reallocation. She really wants Ioan to have to pay those. And her explanation is basically because he didn't agree with the report. He doesn't have to agree with the report. Like, there's nothing in the stipulation or in the laws that relate to relate to custody evaluations that suggest you have to agree. You don't have to agree with it, of course. It's like kind of assumed. Wouldn't you kind of assume that if there's a custody dispute, probably one side is not going to agree with it or the other. But that was it. That was it for the cross. We ended with the Dr. Dupay, and yes, it does state it's subject to reallocation. So if the judge wants to divide it differently, he can. We had a very brief redirect. First, we clarified there had been a question about, counsel instructed you to interpret, XYZ. So we clarified that the only thing counsel for Ioan had instructed him on, meaning told him do it this way, is the definition of the separate property income, and the rest was his own interpretation. So that's dealing with the Derwentag and the Fair Oaks and in that issue. We then went back to the language in the prenup where it says income on separate property and passive income of any form. He just says he believes that what that language means, it calls for a legal conclusion. It's not an accounting question. It's not something he can definitively opine on, whether that includes the residuals or not. That's something the judge is going to have to decide. We turn to the La Jolla residence being used as the family residence. That's in paragraph 9.3. That's the part that talks about titling it as the community asset. But then paragraph 9.7 says, deals with the sale of property, and asked if he sees any ambiguity on how to allocate the expenses or allocate the proceeds from the sale. No, he does not see any ambiguity in it. It's in its own paragraph, so you deal with the one that is more specific to the situation. We then turn to Alice's Hoare's account with the balance of $23,024 is declared in the prenup agreement. The transfer of £97,000 into the account in 2011, which seems to be what Janina had been referring to as the capital account, and then it was closed, but like that got very confusing to me. From the redirect, Joe makes it sound like transfer of £97,000 into the account in 2011. That's part of why the balance was 168, because there's a big infusion of money into it in 2011. And there was no such asset, no separate, bank account or something like that, that was disclosed as part of the premarital agreement. So nothing that she had that would account for that as separate property. So supporting the argument that this is commingled. Asked about whether there were earnings deposited into the account during the marriage, he says he doesn't know what the source of the deposits was. And that's the problem. When you don't know, you can't, you see money coming in during the marriage. You kind of presume that it's community. And it's the burden on the person who is claiming separate property to prove that it's their separate property. So they're the ones that have the obligation to establish that the deposits coming in were from separate sources. And they didn't provide the documentation to be able to do that. He's asked when an account is commingled, what's the ordinary process for dealing with that? Janina object to that on the grounds that commingling is addressed in the premarital agreement, and that was sustained. So there's a provision in the premarital agreement that overrides the, does it override the responsibility to characterize the accounts as of the date of separation? He says no. So to whatever extent, the premarital agreement deals with commingling, you still have to be able to characterize the asset, and don't know how you can do that if you don't know what's the source of what's going into it. As to the time period of January 1st, 2021 through December of 2023, there is no spousal support order in place, but there was the premarital agreement. This is going to an argument. I already know where this is going. This is going to an argument that Ioan paid those amounts voluntarily and not under obligation, because there is a for it to be credited as spousal support under California law, it has to be paid in the belief that you're obligated to do that. And so without a support order, there's no court imposed obligation. But so his argument is that the premarital agreement is what created the obligation. And so, yes, he paid it, but it wasn't like he was doing this as a gift. He was doing it because he was legally obligated to do it under the terms of the premarital agreement. And you can bet if he hadn't, she'd have been howling. She'd have been absolutely howling over him not complying with the agreement. So he said there was a dispute over the validity of the premarital agreement at some point, but that was resolved. As far as allocating all of the mortgage payments to Ellis, he did that and asked if Ioan being reimbursed, and the net result was that, yeah, he would have gotten his principal back. that's what she's alluding to. He paid down the principal, so he would have had more equity in the property. He agreed that reimbursement is a legal issue, but there were no Watts and Epstein's calculations done in this case. So now is the time to pause to talk about Watts and Epstein. These are a couple of cases out of California that deal with if one party is using a community asset for their own benefit, such as, one person remains in the family home and another person, the other person moves out, they can be charged the, reasonable value of the use of that property as part of this calculation. I forget honestly which one is Watts and which one is Epstein, because like they do always kind of seem to go hand in hand. And the other is if one of the parties is using separate property to pay community property debts, like a mortgage, then they can get a credit for those payments that they've made. But the issue with Watts and Epstein credits is that the party who wants to use them, they have to give notice that they are making a claim for this. They have to give prior written notice, and they have to, specifically calculate it out. And so none of that has been done. There hasn't been the notice. So this argument, it's just not entirely clear to me that it's proper. This argument that he got reimbursed for his principal, because they didn't like follow the kind of prerequisite obligations to be able to do that. I'm not entirely sure. I was like kind of trying to do some quick math in my head anyway of like, is the reason why they didn't do Watts and Epstein a demand or a notice because Alice would have ended off worse under that scenario? See, the thing is, if the mortgage is $38,60, but and so Ioan can recover, he can recover half. He can recover half of that, get a credit for half of that. So that's, oh God, not good at math in my head. $1,900, $1,930. He gets a credit for that, but then Alice gets charged the reasonable use of the property, and that's a rental value. That's like a market rental value for a property like this. I don't know what it is. I don't know what the market value, to rent that house is, but just judging by kind of what she moved into, the $6,500 a month, is that roughly equivalent? I mean, it was a townhouse, not a house. The old house had a pool, all these other things. I don't know. I could see a scenario where she ends up worse because, the value to rent that house would be significantly higher than the one half of the mortgage that she would be, getting the credit for. So I kind of think there might be a math issue, and that's why they never went down this road. But now, she's complaining about the fact that she didn't have to pay rent between January 2021 and April of 2023. She didn't get anything out of, the sale of the home in terms of like none of the equity payments, the mortgage payments went back to her in terms of equity. But that's kind of how it works with any landlord. A landlord buys a rental property. They have a mortgage on it. You pay rent to the landlord. The landlord pays the mortgage and gets equity in the property, and you, the renter, get none. Like that's kind of pretty normal in real estate. So I'm just really not sure. I'm really not sure where they're trying to go with all this. I don't know if this a lot of this argument is even going to be allowed because they didn't give notice of the Watts and Epstein claim. So at the end of the day, most of these decisions are extremely discretionary with the court. He does what he thinks is fair and equitable under the circumstances. You have to allocate the community and the separate property. You have to characterize the nature of the assets before the court. But his job is just to make fair and equitable distributions and determinations of you know, the what the premarital agreement calls for and stuff like that. So it's just ultimately going to come down to kind of what he thinks is fair. You know, what does the judge think is fair in this situation? Is it fair, you know, that Ioan paid for her to live in the house, didn't get to sell it during the meantime, and gets no credit for that, as she apparently seems to think? Is it fair that he gets all credit for that, even though he got some of it back in terms of equity? The house didn't get foreclosed on. You know, I don't know how he's going to see it, but so the bottom line is, I kind of was looking at these numbers and thinking, well, like, what if he, okay, so let's say he maybe just splits the baby. Okay, half of the mortgage payments he'll give Ioan credit for, and treat that as spousal support. It's still not even close to making up the gap of that overpayment. We're still at like $300,000 of the overpayment. So I'm not seeing how this math is mathing in Alice's favor, pretty much no matter how you work this out. I really don't. You really do have to be in a situation where the judge kind of sees absolutely everything her way and gives her absolutely everything that she's asking for. And then she's pretty close to like scraping even. I don't know why we're having this trial. I really don't. I really don't know why we're having this trial. I have a hard time thinking that this is better than anything she would have been offered pretty much at any point over the course of this litigation. We had recross, where we just kind of reestablished Alice had not made or Ioan hadn't made any request for reimbursement for overpayment of support between January of 2021 and December of 2023. Like, he hadn't filed a motion in the court for reimbursement. And so, you know, so what was the purpose of him doing the analysis according to, you know, Janina's question? Well, it was just to show that he paid these expenses for the benefit of Alice and the kids that exceeded what he was required to pay under the premarital agreement. So he's not asking for reimbursement as a Watson Epstein credit. He's arguing, I paid these for her benefit and therefore their support, because I had an obligation under the terms of the premarital agreement to support her. And the purpose of support is to be able to pay housing and food and things like that. And she was able to do that because of these payments. So it will be interesting, I think, to see how that that decision ultimately comes down. The judge had a question about a portion of the testimony on cross-examination regarding the selling of the luxury clothing and whether he made an actual determination of whether that was a recurring income or not. And he just said it's for the court to decide. So I don't know, without the exhibits, you know, it's hard to see what he's relying on. If it's a one-time payment, a lot harder to argue it's recurring. If it's, you know, things that she sold 5-10 times, seems like a bigger argument that it's recurring. So it's one that just seems like it's probably going to come down to the details. He was excused but subject to recall in case Lesgert testifies. So it sounds like may not be completely off the table. When they said before she wasn't going to testify, I guess maybe that was just for the DVRO. Maybe they're reconsidering it. Not sure. But they did not completely let him off the hook. So we finished with Mr. Green shortly before lunch. We did, we had a little bit of a conversation at this point about logistics. Last week, a witness has signed up for remote testimony. There was another request today. So Joe explained that Lynn Blank and Maryellen Mulcahy were being taken out of order today. The office had been prepped to present impeachment exhibits to her, like they had this process where Janina would email impeachment exhibits to Joe's staff. Joe's staff would then email them to the witness on Court Connect in real time so that the witness's email address would not have to be made part of the court record. But they could also, be presented with Janina's impeachment exhibits. So these, he said, are third-party witnesses. They will not take long, and for their convenience, we should handle them. So they are planning to join at 1:30. Joe says that he wants to know if the judge wants to know, does this relate to the DVRO renewal? And Joe says it's pertinent to the claim of termination of spousal report, and reiterates they have rested on the DVRO renewal. The judge wants to know, what does the prenup say about termination of child support? And Joe says it just says further order of the court. So Janina says the premarital agreement states that the duration of the support for a marriage that is over 10 years is until the death of either, or Alice's remarriage or cohabitation, or pending further order of the court. So I think she wants to argue there's no grounds in the premarital agreement to terminate support, but it does seem to be anticipated pending further order. She says the calculation is clear, and what she's calling 4320 factors don't apply, so don't know why the witnesses are relevant. We kind of reiterated that Lynn Blank had filed a declaration that related to the request to renew the DVRO, and that had been not admitted because it was hearsay during that portion. Ms. Mulcahy didn't file a declaration. So Janina just basically says if Lynn Blank testifies before we have closing on the DVRO, then I want to be able to cross-examine on that. And the judge says, well, we should hear them both before closing, because I see them as kind of spilling over into the renewal issue, but also relating to the other order of the court part of the premarital agreement. And Joe says basically, as a public policy issue concerning the abuse, that's really what they're asking for. Make him not have to pay spousal maintenance, spousal support, because of Alice's ongoing domestic abuse. And that is contrary to public policy to force a victim to pay support to their abuser so that their abuser can continue the abuse. That's kind of a problem. We had our lunch at this point. There were some kind of scheduling things that came up over the lunch break. First, out in the hall, there was a conversation between Joe and Janina, and apparently Janina wants to not have court on Friday. And so originally, the way that these things are ordinarily supposed to go, I guess Joe is supposed to call Alice in his case in chief on terminating child support or terminating a spousal support. But in order to potentially accommodate maybe not having court on Friday, they agreed that he could just cross-examine her on those factors after Janina calls her instead. And Ioan made a comment about, as long as it, if it doesn't sacrifice any of your time with Alice. He's very clear, I want you to get done what you need to get done. And if this would interfere with that, then you should say no. Well, we went into court, and first off, we had a delay. We had an initial delay after lunch from 1:30 to 2. And that was because the bailiff had been called away to like deal with something else that was going on, some unhappy person in some other part of the courthouse. And it's the court's policy that it's the bailiff who they lock the courtroom like during the recesses and lunch and everything like that. They kick everybody out. I learned this the first week because one of the recesses, I just stayed there. It's like, it's 10 minutes. I don't, need to get up and leave. No, they got me up and shushed me out so that they could lock the door. And so apparently only the bailiff is allowed to unlock the door and let people back in after the recess is over. So since the bailiff was gone, they couldn't unlock the door and let us back in. So we had to wait till the bailiff got back until about 2:00. We then had a long delay trying to get Ms. Mulcahy connected on the Court Connect. In the meantime, we had some more scheduling conversations because the judge just brought up. So first off, this Wednesday as well, we are doing another only in the morning session, but otherwise we are scheduled to be full days this week. But then he also volunteered. The week of March 16th is wide open. He had an April 23rd trial that has gone away now. The week of April 27th is open. May 4th, May 11th, May 18th, May 26th, all wide open. So what he is indicating is that if we don't get everything done here, there's more time. There's more time. I see this as a real double-edged sword because on the one hand, yes, great. Then don't rush. Don't cut your presentation short out of concern that, like, if you don't get it in by Friday, it's not going to be considered. So that's a good thing. But do we want this hanging over everybody's head for even longer? Do we want this? Do we want this dragged out again? Do we want to spend more on another week of trial? Like, surely we don't. Like, Judge, why'd you go there? Why did you go there? You know what this made me think of? This made me think of when, you look around and you're like, I've outgrown my house. We have kids now, we have all this stuff and we don't have room for it. So we need to buy a new house and you get a new house and then you instantly fill that new house with all kinds of new shit you buy. That's what this is kind of making me think of. They will fill whatever time the court gives them. And that's just kind of the bottom line as I see it. So I sort of wish the court had been a little bit more reticent about its availability to just go ahead and keep going if you feel like it. No, keep a leash on this. This needs a leash on it. It needs to be done. It needs to be wrapped up. At the same time, we got to acknowledge the reality that this does seem to be taking so much longer than anybody anticipated when they were first estimating the timelines and stuff. All of the witnesses really have taken longer than they expected. The whole DVRO renewal took an entire week. Like why did it need, it needed to take that long. And that was even with not presenting so much of this stuff that seems to be highly relevant to the DVRO renewal, like Detective Morales. But they're treating it as part of the termination of spousal support issue instead. And so it's just, I don't know. So that was kind of the double-edged sword on the scheduling that, yeah, they might be able to kick it down the road for more of this later on. It's just I can't celebrate that. That doesn't seem like an awesome thing. So lots of tech difficulties trying to get Maryellen Mulcahy set up on Court Connect. We had a really hilarious moment because she finally did get on and she was on video. They were like running out to the hall, trying to call her. The staff is calling her. They're trying to walk her through how do you get on, how do you get logged in and get everything set up to be on Court Connect. So she finally like gets connected and she's on. But it's not clear to me that she understood. She's still on the phone talking to somebody who's talking her through, or she sees the phone ringing and she says on the video in front of everybody, but before court is in session, so this probably won't be in the transcript. Now Ioan's calling me and I have to look at Alice. It's a disaster. So she's just panicked. She didn't want to see herself on the you know, the computer screen on the camera, and she's trying to, oh, it's a disaster. I have to look at Alice. Oh, I died. I thought that was so funny. I don't think Alice was terribly amused by that. There was a little bit of that lip pushing out thing, you know, a little. I have to look at Alice. I'm sorry, Ms. Mulcahy. That is just the nature of court. So the judge first gave some ground rules. Speak slowly, speak more clearly. If you talk fast, it can garble the transmission. Don't put things in front of your mouth or in front of the microphone because that can mess up the sound. If an attorney says objection, stop and let me rule on it, and then I'll tell you whether to answer it or not. We clarified that nobody was in the room with her. And at that point, she was sworn. Explain that we're using the first names of everybody except for the children, using the initials. She had to make a note of that. She's like, I don't think of them that way. I need to write that down. So Peter Langois did the examination of Ms. Mulcahy. So this is the first time we've seen him kind of do stuff in court that isn't just like assisting Joe. And he did a pretty good job, I think. Ms. Mulcahy, she seemed a bit flustered. You know, this is not her arena, not where she's used to playing. I think she was probably just very nervous and uncomfortable. But she had a tendency to kind of ramble on in her answers, and then eventually she would get cut off. They would strike a whole bunch of it, and then she seemed like maybe she was a little bit offended about that. She's like, I'm just trying, you know, like, yes, we know, but please, you know, judge kept telling her, like, please just answer the question, and just that. We have to do things the way, you know, the evidence rules say. So first, who is she? She represents Ioan as an actor, and she used to represent Alice as an actress, but she no longer does. After January of 2021, she had communications with Ioan, may or may not have had email or text communications with Alice. She'd have to look at documents to be sure about dates and timing. So we start with a text she sent to Ioan in April of 2021. She sent it because she had been concerned that certain social media posts were provocative and derogatory and not helpful to either actor. She suggested that they be taken down and that things of that nature should not be posted. So she shared that opinion with Alice, who did not respond well. And we clarified the posts she's referring to are posts that Alice made. So this text communication to Ioan reflected or like contained statements that Alice made to her. She explains that she texted Alice asking to take the post down because they were not helpful to either career and to consider not posting. She said the response was hostile, and she shared that information by text. Peter tries to get the text into evidence at this point. Janina objects to hearsay and the best evidence rule. So she points to quoted language in some different paragraphs, quotes, and the judge agrees that's hearsay, so he sustains the objection to the text. However, Peter is clever as a lawyer, and he realizes, well, you can just testify about all this stuff, even if you don't have the text and evidence, it's fine. So he just asks, well, what posts? What posts were you responding to? And she said one that stood out was one where Alice was talking about the daughters. She referred to the older daughter as bright like herself, and the younger daughter as not so smart like her husband. She said she felt hurt on behalf of the children to have something like this posted, didn't feel that it helped. And Alice got upset and was, playing victim because now she's not a good mother, right? Now well, no, you say shit like that about your kids. That's not being a good mother. So in this text message, she quoted what Alice was raging at her. She quoted that back to Ioan. The judge wants to know at this point, was this part of the original restraining order hearing? And the answer to that is no. So he says, for whatever it's worth, continue. This is where I'm kind of thinking like they already rested on the restraining order, but the judge is still seeing the overlap. He's like still kind of looking at it in that sense anyway, because it doesn't really matter if it preceded the restraining order if it's not going to the renewal. If it's going to termination, it's not a limited scope. But maybe he sees it that way. I don't know. Maybe he thinks the original restraining order needed to include any and all abuse, that went on during the marriage and during the separation and so forth. So, but he did kind of imply move on, but Peter just kind of continued with his questioning and it was fine. So he asked what was hostile about Alice's response. And she said, well, most clients, when a manager gives them measured feedback, they tend to listen or they tend to think or reflect on it or so forth. And this was, you don't know how much I defend you and go to bat to you for you. And it was attacking her when she was just saying it's a bad look to post negative things about your kid and making fun of your husband. She also, like, a lot of these posts were late night posts. Late night, were they full of spelling errors? Were they a little rambly, a little incoherent perhaps at times? Is that what you're getting at? There is another email now. This is one that was sent to her and another rep by Alice in June of 2021. She says this one is nonsense and it was very shocking. Janina objects to this on the ground that the date is misstated. It's in the British date. So she says it's actually November 6th of 2021, not June 11th, I guess. I don't know. The British date, I guess it depends on the source of these particular documents. But there's some language in this email that is to the effect of he thinks he's God, so he thinks he's going to get through this and I'm going to disappear. I'm not. I have nothing to lose, so I'm going to go all out. And when people have nothing to lose, they get dangerous. And Maryellen said she took this as being threatening, as being scary. Threats that she perceived included threats to her, Maryellen's business and her career, to ruin Ioan's career, to go all out to do something. Maryellen also said she knew nothing about Bianca, but Alice was accusing them of knowing everything, knowing all about it. She says, I don't want to know about my clients' personal lives. And just generally, there are many outlandish comments in here. She was very upset by it. A comment that I gave up 10 years of my career for him. She says, I didn't understand that because Alice had stopped participating in her career long before this. She stopped auditioning. She stopped taping. And it had nothing to do with Ioan. So she thought it was just grandiosity, honestly. Grandiosity, it could very well be. This email was admitted into evidence, so someday we'll get to see it. Another series of text messages. Looks like the first couple pages were between her and Ioan, but then there were some from Alice. So she had blocked Alice on her phone and on her laptop, but not from her office computer. So Alice somehow managed to message her on her computer IM. And so she cut and pasted it to send it, to share it with Ioan because she thought it was important for him to know what Alice was asking. There's another objection to this one on the best evidence rule and hearsay. The judge says, well, it's hearsay. He wasn't sure what the best evidence rule was. The best evidence rule was, is that if you're going to testify about the contents of a writing, the best evidence is the writing itself, not the testimony about it. And so he didn't know that, but he just had her kind of explain, and he's like, so is there a dispute as to authenticity? And she said in foundation, so it's sustained on all those. We're not going to get this particular text into evidence, but once again, we're just going to be able to testify about what it is. So Maryellen tells us in this message, Alice was asking for a favor. She said she wanted proof that after Ioan had left her, that their finances had rapidly decreased. Maryellen says she wasn't working with Alice anymore and she had blocked her, so she was surprised to receive this communication and she wasn't inclined to want to help her out. This, I guess, was stricken, is not part of the specific question that she was asked. Just in terms of her reaction to it, I think. We then get a message from Alice that was to Maryellen as well as to somebody else. She doesn't recall the date, but there is a date on the top of the page. She says it was upsetting to see this message again, to be reminded of it. Alice was accusing us of having been aware of an affair for years. She also received a bunch of incoming emails from journalists who were asking for quotes on the divorce. And she received these inquiries during the October-November 2021 timeframe. She got a number of them. She said she never responded to media requests. She would just turn them over to publicists and to the client. And that's what she did in this case. On November 14th of 2021, she received an email or a text from Alice that she shared. Again, it's not coming in because of hearsay and foundation and so forth, but she can testify that the gist of the message was that Alice said, I'm choosing the wrong side and I'm going to go down with him and I would regret the decision to side with Ioan. And she said that bothered her because she thought she had left her, as a client, blocked her and everything in an effort to avoid things like this. Yeah, that's what you do when people start texting abuse at you. You tend to block them and, drop them as a client. Drop them as a client. We would not tolerate stuff like this in my office. Back in the day, people call up and want to berate the staff. Okay, you're fucking out. You're gone. You're gone. You're not paying me to abuse people. It's not going to happen. So she said that it was upsetting and she shared that message with Ioan and discussed it with other members of the team. We then got several social media posts, about 8 of them. They were screenshots her assistant pulled off of social media for her to see, things that Alice had posted. Janina didn't want them in because they are cumulative of posts that Ioan had already discussed, but the judge said it's just going to be, she's like, we'll find them. She's like, well, but I have to flip through. So the judge is like, it's going to be easier to just admit them. And then if you want to argue, you know, it's cumulative, you can. But just for efficiency's sake, we're going to let them in. So we did. Her reaction to them, she was shocked, she was outraged, she was upset, she thought that they were untrue, and she was really not happy about them. She was not sure that Ioan is really on social media or paying attention to Alice's social media, and so that is part of why she collected these to discuss it with him. She's asked, as his manager, as a manager, has Alice's posts impacted his acting career? This was objected to as speculation and improper opinion, and that objection was overruled. So he is going to allow her to give an opinion about the effect on his acting career. Maryellen says, I have represented actors for 40 years, and I definitely think they impacted his career. They affect how agents and publicists respond to him because they wonder if there's any truth to it. She talked to his team, you know, had to convince them that these were malicious, they were angry, they were hostile, they were bitter statements with no basis in truth. She says the manager is the first one to get a call if somebody is late to work or if somebody is like drunk on set and stuff like that. So that's, I'm assuming that's what these posts were about. And she's saying, you know, that didn't happen. But people will Google an actor the first thing if they're thinking about hiring somebody. They will Google him. And so the articles from the Daily Mail quoting these posts and the lies in the media would come up. And so it would cause hesitation because producers and directors and friends and all these people were making phone calls. It was a huge problem. She says it didn't stop him from working, but it was a problem. 100% it was a problem. So then we went across. We went first to the email that Alice sent that she corrected the date on November 6th of 2021. I'm not sure why, because she didn't really ask any questions about it. Just there it was. Then the email that Alice sent that she received on the one that was like ranting about you know, you guys, you knew everything and so forth. She received that. She's asked if that was on October 27th of 2021. She says, well, that's the day at the top. And that's the same date that Ioan announced his relationship with Bianca on social media. She says, I don't know. Is that supposed to be a justification for emailing abuse to Ioan's manager and whoever else was on this email? Is that supposed to be the justification? It's the same day he announced the relationship on social media, so it's okay. Is that really where we're going to go here? I kind of think we are. I kind of think that is what the argument's going to be. As far as the inquiries from the news outlets, she's asked if after Ioan announced the relationship with Bianca, did the news media take more interest in the dissolution? So now she's trying to blame Ioan for the bad press. And she says, I don't know that to be true. Doesn't know that they were more interested after he announced the relationship. The press inquiries that were on her exhibit, they came in after October 27th of 2021. She's like, well, that's the date on it. We then turn to her testimony about Alice. Alice stopped participating in her career long before the separation. She agreed she had no personal knowledge of what Alice and Ioan had discussed about which parent would stay with the kids or things like that. She says, well, but I would hear from both that they didn't want a nanny. It would be one parent or the other that would be staying home. She says Alice wasn't responding to scripts or auditions, and when she did have jobs offered, she was not feeling well. She had medical issues and she wasn't enjoying work. So there was work for her to get, and she was asking for it. But apparently when it was being offered, she wasn't taking it. In May of 2024, did she request that offers to Ioan be communicated to go by phone and not email? So there was no paper trail for the case. This is the big gotcha on direct, or on cross. And she said, we were told that documents might be requested by Ellis. So we tried to have offers called, but the reality was it didn't work because Ioan's agents were older. They weren't, I guess, very tech friendly, or just not amenable to change or something. I don't know. So they ultimately end up emailing scripts and offers and so forth. The request was not viable. The concern had been that Alice would try to subpoena the agent's records. And so they wanted to call in offers out of an abundance of caution. She's asked about a Kupu project. This is spelled Kupu. And she says, I never heard of it. It sounds terrible. Sounds like maybe the kind of thing you wouldn't recommend your client accept, even if it's offered. Kupu. So then she is shown an email that she sent from May 1st of 2024. While they're getting this up, because remember, they have to do this process. She emails it to Joe. Joe emails it to the witness. The witness pulls it up. And everybody has to have a paper copy in the courtroom and stuff. So they're getting all this stuff. While that's going on, the judge informs us all that there's going to be a demonstration. He just got notice that there's going to be a demonstration about the war in Iran down at City Hall starting at about 6 o'clock. City Hall is about, it's two blocks. It's the way this block is set up is you have the courthouse, the Stanley Moss Courthouse. Directly south is the county law library, and then directly south of that is City Hall. And right next to the courthouse is a big park, Grand Park it's called, and that park runs all the way down to City Hall, and I believe is where people tend to congregate for these types of things when they happen. So anyway, he let us know, make your travel plans accordingly by 6 o'clock. Apparently there's going to be a crowd down there. So this was also chaotic. The witness is saying, I have an office emergency. I'm not seeing anything in my email. This is really frustrating. She does not like this process at all. It's feeling kind of bad for her. But eventually she does get the email, and it involves Maryellen. It's from her. It involves Hildy Gottlieb, who is a CAA agent on Ioan's team, as well as Lexi Alvarez, who is a manager at her Maryellen's company. And is this an example of you requesting an offer being phoned in to Ioan? So Joe objects to this on the grounds that the documents that were produced by CAA were produced pursuant to a confidentiality agreement. And Janina agrees. Yes, that's what happened. And the judge says, well, so then we can't market or use it. And Janina's like, well, no, we can use it. We just can't make it part of the public record. And the judge is like, yeah, that's not how this works. The judge, I'm impressed. The judge knows his common law public right of access issues. Yeah, that is not how it works. If it is part of the deliberative process, part of what the judge relies on to make his decision, then there is a very strong presumption of public access. So he is like, yeah, it doesn't work. And Janina says, well, it's the same protective order that already applies to the financials and things like that. Nobody put the bank statements into evidence. So I don't know why you're bringing that up as an issue. And so the judge is saying, look, don't you already have the testimony that you need? You don't need this document into evidence. He says, we're We're not going to use it. What we'll have to do is we have to give it a placeholder. We're going to take it under seal, but we've already marked it. So we have to put in a placeholder. We're not going to admit it or do anything else with it. And take care to make sure you've prepared your documents correctly. So he doesn't want anything that is confidential being offered or admitted as an exhibit. Because yeah, there's going to be a presumption of public access, and it makes me wonder, have you seen my request yet, Judge? Is that why you're paying attention? Is that why you're paying attention? Asked if she has had no communications with Alice. Isn't it true you've had no communications with Alice since November 2021? She did not know if that was the time frame or not. We had redirect. First, concerning her awareness of conversations about work versus family. During the marriage, she did attempt to find work for Alice, and she elaborated that it was health concerns that caused Alice to turn down jobs. Were there other reasons? She said, well, it was mostly pregnancy and health-related post-babies that made it difficult for her to work. And also, after the children were born, it's hard to lose weight after having a baby, especially 2 back-to-back. And she had some sympathy with that. And also, it's hard to find a good nanny. She says there were work opportunities presented to Alice, and she could have pursued them, but she chose not to. I was kind of confused why they didn't get into the fact that Alice actually did work pretty extensively during the marriage. In fact, this show that she is now making her entire living off of doing the conventions for, she filmed after the children were born. She has something, I went in and counted, I want to say it's like 16 or 17 IMDb credits since the marriage, since 2007. They had Ella in 2009. So, you know, at least 10 to 12 of her credits are from after the children were born. To me, that seemed like kind of an important point, because otherwise this is sounding a little bit like what Alice is saying. Oh, we had an agreement that I would work, and, you know, I would stay at home and he would work. Which is like, you know, not true. It's, you can look at the fact that she worked after they had the kids, like they obviously did. But they didn't elicit that. I'm really not sure why. Maybe they're just going to bring it out through some other context. But it seemed like that would be a highly appropriate thing to ask the agent, but it didn't get asked. So just the fact that she was offered work and declined it. In May of 2024, we talked about the request to call in the offers. You know, she's asked in the prior 6 months about how many offers did Ioan get, and she says she doesn't remember specifically. She said that since there were protocols in place for Ioan's for vaccines and masking, that Ioan worked after that, and then also after the actors' strike, he got work. He did a series in France. He did a movie in Atlanta. He did an episode in a well-regarded CBS series. She said, Ioan is talented. I can keep him working, but it's difficult. And the request to do everything over calls actually made it harder to get work. It meant more communications, more work, people having to do things differently. So it was making it harder to arrange things for him. On recross, she's asked basically who she wanted to know if Ioan is the one who requested that the offers be made by calls instead of in writing. She said it was a consideration that the team made to call the offers. They thought it would be protective for him. His team consisted of his agents, managers, lawyers, and publicists. As far as Ioan's involvement, he was aware of the decision. They wouldn't have done it and not run it by him. But It doesn't sound like he was, you know, the impetus for it or anything. He was simply aware that that was how they were going to do things. So again, this is it for her. She is excused. Joe explains once more she is just for the quote unquote other part of the case, the financial part of the case. They've already rested on the DVRO. Her testimony is not being offered for that purpose. Lynn, the estimate was her testimony would take 1.5 to 2 hours. So we were going to get started with her and then pick up tomorrow, but then Lynn, we also couldn't get on Court Connect, and it just started to delay and delay. We initially had like 20 minutes to work with, and by the time we were down to about 10, the judge is like, look, never mind. Why don't we just call it a day? So Janina wanted to clarify before we close. So then tomorrow the plan is we're doing Lynn and then the closings on the DVRO. And Joe said, well, we have Detective Morales coming in. He's coming in at 9 o'clock and he'll be very short. And so the judge clarifies we're going to do this witness and then the detective and then the closings. And that seems to be confirmed. I think don't they need to swap the detective and Lynn Blank if Lynn's going to take an hour and a half and the detective is going to be there at 9? You don't want him sitting on the bench outside all morning getting annoyed and then coming in to testify for something very brief. Try to find a way to work him in and get him out of there. That's my thought about it. So that was why the day ended up being a little shorter, a little less happening than we might have wanted or might have anticipated. Patrick Green got there early, but he still took up the time that they had all the way to lunch. So it didn't save them anything in terms of like being able to come back and do the argument. We had the delay, of course, getting late started, coming back late after lunch, hard time getting people on Court Connect. It was rather chaotic today. So hopefully that's not an ongoing thing. You know, hopefully it becomes maybe a little bit easier to walk people through how to get connected on the Court Connect system so it doesn't take like half an hour just to be available to answer questions and so forth. Although that little interlude about I have to look at Alice, that was pretty hilarious. That made the wait all worth it for me. So that was our day. That was our day. It wasn't like a big bombshell day or anything like that. At least not if you have been following the pretrial process in the case. Nothing really new, at least that we heard, you know, maybe a little bit of the details about Alice's treatment of the manager. But you know, the emails, I haven't seen it yet. We'll see it at some point. That will be new. That will be new information. But the financial information we already pretty much knew from the pretrial filings. Alice's trial brief in terms of what her argument is on these issues. There's nothing really materially different from that. You know, she's kind of trying to make a Watts Epstein argument, but she didn't preserve it. She didn't do what she needs to do foundationally to be able to make that claim. And my understanding anyway is that California is quite strict on that. You don't get to just, you know, bring that up by ambush, you know, at trial. It is something that requires prior notice and opportunity to flesh out and not just be sprung upon somebody by surprise. So I don't know if that's gonna be able to play in or how exactly that will work. But I think I really do. I think the bottom line for me is I think this was probably a math issue. You know, so now they're trying to have it both ways. They don't actually want to claim the Watts Epstein credits because it would probably put Alice in a worse position if she is being charged the reasonable rental value of the La Jolla property. but she's trying to get the benefit of it in order to argue that it shouldn't count as spousal support, even though she was only able to continue living in the house because Ioan continued to pay the mortgage. A lot of judges' discretion and all this stuff, and so it's kind of why it's important to make a good impression on him, right? Maybe that's why Alice was smiling so big this morning. Smile, like me, Judge, like me. Don't adopt the positions of Ioan's accountant. See everything my way, because if you don't, I am really fucked from a math standpoint. And there needed to be a point to this trial. I'm wondering what the point is. If I'm wondering, surely the judge is wondering. I think everybody can understand why a DVRO renewal would go to trial, because nobody's going to want to stipulate to that. It's just, it's got too many implications. But all this other stuff, it just seems quite tenuous and like quite a bit of a reach in terms of the finances and the arguments that she's trying to make. The separate property argument for her bank account is just laughable. It's just laughable. I don't know how you can, with a straight face, make a good faith argument that it's separate property when you haven't met your burden to show what's the source of the funds going into this account during the marriage. It's like commingled by definition, and so that puts a burden on you to prove certain things. And if you didn't provide the bank accounts after 13 years ago, we've got 13 years of bank statements that you haven't provided for this account. I don't know how you expect to meet that burden. So it just speaks a lot, I think, to what she didn't want the forensic accountant to know about that account activity. It's one of those things where, yeah, they were very much dependent on Ellis to produce those voluntarily, because trying to subpoena bank records from a foreign country, this is a discovery nightmare, like on an X level. It can be difficult enough to try to subpoena documents from like another state, or to talk to a witness in another state. Many states have like interstate agreements. There are these kind of model statutes for how to do interstate discovery and stuff like that. Many states have adopted them, but not all of them have. And so if I want to go and, subpoena records in, for example, Texas, I'm going to have to go look at what are Texas's rules. My state court, its jurisdiction ends at the borders of its state. And so its orders have no power, no force and effect beyond the borders of the state that we're in. So if I need to go to another state, first thing I got to do is look at that state's law. And how do I do it? Most of them will have some kind of process for foreign requests, foreign discovery. Maybe it's the interstate process. Maybe it's their own process. You got to see what it is. You got to follow it. You got to figure all that out. Sometimes requires you to, just a bit of a paperwork nightmare. But it's not insurmountable. You can get it done. It's just it requires effort. It's a pain in the ass. International discovery is like on a whole other issue, because now you're dealing with a request from a court in a country that has no standing, no legal, really anything with this other country. There's like not treaties about international discovery. It's more of a diplomatic issue. So not a good, clear, obvious mechanism to just independently go and do it yourself. Get these bank records from somebody else's account in a foreign country, in England. So they were just kind of stuck with what she was voluntarily willing to disclose for whatever reason after 2013. Didn't think we needed to know about it. I, of course, am going to infer negative things about that. I suspect the judge might as well. I suspect the judge might infer, yeah, there's a reason why you didn't disclose all of these years of bank statements, and that's because there's stuff in them that is bad for you and is bad for your case, and you really didn't want me to see it. Because there's a presumption, not just in general litigation, that you're supposed to be doing discovery in good faith and stuff like that, but particularly in a marriage, spouses are fiduciaries to each other. They owe each other duties of trust and honesty, those kinds of obligations. And so to not account to your spouse for things that are going on with assets during the course of the marriage, it's really not good. It's really not good. It's not a good look. And I very much tend to think that that is going to draw a negative inference from the court. So that was our day. Not the most eventful. We have a new member here, Animals Over Human. Welcome. Welcome to the channel. And Lola the Good Dog 26. Fun fact. Alice broke off her 8-year engagement to Olivier Picasso, grandson to Pablo, when she met Ioan. She traveled in pretty fancy circles, and in my opinion, I can't imagine her ever totally broke. Well, fun fact, she did not break off her engagement to Olivier Picasso when she met Ioan. There was significant overlap between her getting together with Ioan and her simultaneously being engaged, so to speak, to Olivier Picasso. But yes, he wealthy man, seemed to have kind of kept her in high style. Don't otherwise really know personally, much about her circles or her friends or anything like that. In fact, one of the things that's kind of stood out to me about Alice is how she doesn't really seem to have a lot of long-term friends. It's just not something you really see on her social media, on her comments, stuff like that. Like, most people are that are on Instagram or Facebook, or whatever. Like, that's kind of part of the thing, is to connect with your people that you're close to, people you grew up with, stuff like that. And really don't tend to see stuff like that with Alice. So not real sure about those relationships and how deep they were versus potentially just being superficial and in the moment. Really don't know. But yeah, there was some overlap in that relationship. In fact, if I remember right, that was one of the things that Ioan's mother did not particularly like about Alice. But I don't remember if that was in one of the emails or if that was just just something to kind of infer from the context and everything. So that was our day. That was our day for finances. So what does that mean now tomorrow? So now tomorrow, we're expecting Lynn, we're expecting Detective Morales, and we have once again shifted the closings on the DVRO. And if we're going to get a ruling, in quickly, getting the ruling on that has also been shifted to tomorrow. I got to assume at this point that's going to be tomorrow afternoon, because we got Lynn lined up, 1.5 to 2 hours, and Detective Morales, that's going to take up our whole morning. That's going to get us to lunch. So maybe we are looking at the DVRO stuff in the afternoon. I really hope so. I'm a little, I don't, alarmed is not the right word, but it just seems that the judge is kind of confused about how the division of this case is taking place. And so just like the comments he made today about Lynn and about Maryellen and how their testimony, he wants to hear it before closings on the DVRO because there's overlap, but that's not what it's being offered for. And Joe keeps repeating and emphasizing, we've already rested on the DVRO. This isn't about that. And I'm not sure what to make of this state of affairs. On the one hand, it's kind of like, it seems like Joe is just trying to kind of keep things tidy for the judge, trying to have this clear division of what's DVRO related and what's termination of support related, abuse stuff. But the judge is almost like, not paying attention. He's kind of like overriding that in some ways, at least in his own mind. They both kind of seem to have very strong opinions about how to present this case. And I guess those opinions aren't necessarily corresponding. And so just the easier, the sooner the DVRO issue gets resolved and gets decided, then I think the easier it will be to deal with the finances, because it will just be clear at that point that this is all that we're dealing with. And so then that way, okay, if the witness is called, does this have something to do? What's the argument for this having something to do with the termination of spousal support? If there's a question about relevance and so forth. Then it's clear where kind of everything stands and what the argument is. So I really hope we get that done. But otherwise today, yeah, it wasn't like big bombshells in terms of new information, at least if you were following the case closely. Couple of things that didn't get raised that I'm like, why didn't that come up? I really wanted Alice's, what she had in the account when she was saying, I have no money, I need money, pay me money, help me, not get evicted, et cetera, et cetera. They did that pre-trial in the declarations, so the information is available. It wouldn't have taken, a lot of time or effort to present that. And it seems very important to the course of abuse, the plan to smear and the length of it, the persistence of it, the fact that this was still going on quite recently. And it was a lie. It wasn't true. That seems like a missed opportunity to me. And then same thing with Alice's work. The fact that she did in fact work after she had kids. They did not have an argument that she would stay at home with the kids and Ioan would work. And then they followed, carried that out, because in fact, Alice did a lot of work after she had kids. And that really needs to be established. It doesn't have to be established through the agent, but I'm not sure why it wouldn't be. I don't know why you wouldn't. So it's just seems like a little bit of a missed opportunity. Particularly if the DVRO issue is still kind of outstanding. If it's still kind of lurking out there, then why not jump on that opportunity? So that was our Monday. It's not, I didn't see it as negative by any stretch of the imagination. It just didn't move the case as far forward as I might have hoped it would have. It's a little bit more of a kind of slow incremental progress, but progress nonetheless. The bottom line is that the math is very not good for Alice. And that in and of itself, it just seems to me has to raise questions about why are we even here? And if why are we even here potentially relates to this pattern of coercive control and abuse and vengeance and so forth that we've already seen, so much evidence about from Alice's own mouth. She said this was what she was going to do, and here she is doing it. It would be one thing if you had, a legitimate argument for, a big payday that warrants spending what this trial is going to cost. But without that, it just doesn't look like it's really being done in good faith, because the cost benefit doesn't work. It doesn't work. And everybody, like, that's the number one thing that lawyers are doing in a settlement context, is explaining the cost benefit. Like, yes, you can get potentially what you want through the trial, but it is going to cost you 10 times more. So you're not actually better off. And that's why so many cases end up settling, because the cost of trial is far more than whatever it is that you're going to recover. In fact, that's probably a lot of cases don't even get filed because of that reason. Like, look, it's just going to cost you too much to litigate this, and your recovery is so small. So it's not like she didn't know that. I refuse to believe she didn't know that. So tomorrow with Lynn Blank, this will be interesting. We have a declaration from Lynn Blank, as they talked about, from the DVRO application. Lynn is the former organizer, I guess, of a fan page for Ioan on Facebook. But at least after the breakup, maybe potentially a little bit before, she had kind of been buying into Alice's smear campaign, and she was kind of groomed behind the scenes to assist Alice with her campaign, and did in fact assist Alice with her campaign for some time. Definitely during the early stages of the relationship with Bianca, when Alice was, going nuts everywhere online about that. Lynn was part of that. But she has since had a change of heart. She has reconsidered her former course of action and does not feel good about it. And so I feel like in some ways this testimony is probably partly her effort to make amends for what she had done. But we'll see. We'll see. Because we don't know what they have for impeachment. Just the mere fact of her, collaborating with Alice on a lot of this stuff probably means that there is some bad things there. But we don't know what they are. So very interested to hear the details of that. Same thing with Detective Morales. We're gonna get more explanation about how you linked the social media accounts to Alice. A little bit more of a detailed explanation about why that conclusion was drawn. That's what I assume he's for, but we'll have to see. So guys, yeah, hopefully tomorrow will be better, be a little bit back on track, a little bit less chaotic, maybe not so many delays and interruptions and tech problems and so forth. But we'll see. I mean, that's just trial. It can be chaotic, and you get what you get sometimes. So tomorrow is another day, another opportunity. And once again, of course, I'll be there to check it all out and be back to let you guys know what happens. And yeah, if there's anything new and exciting that we learn through the process. So with that, guys, I'm going to go ahead and check out for tonight. I want to thank you all for being here once again. Appreciate you joining me. Appreciate your support. Appreciate all the mods. I haven't called out the mods for a little bit. Everything that you guys do to make this possible, make the chat a good place to hang out, to talk about the case, and everything else that comes up. We get lots of good insights and comments from a lot of you folks in the chat. So thank you, everyone. Appreciate all of you. And I will plan to see you guys back tomorrow night, same time. More updates. We'll see what tomorrow brings, guys. Take care, everyone.